I just wanted to thank you all for taking the time to attend our webinar. I just wanted to just say a little bit about Youth Law so you've got a bit of an idea of what we do in case you ever need to refer to us in the future or get in contact with us for further questions. We are a community law centre. We're the only specialist community law centre in the country. We provide legal information, advice and at times advocacy and representation for children around the country under the age of 25 years. We operate an 0800 number between the hours of 10 and 4 Monday to Friday, and essentially as long as the young person meets our eligibility criteria, the legal service is free. So if you do want some more information at the end of the webinar, we will provide some more information on the type of work we do, but essentially we do a lot of educational work and we work with a lot of young people in schools as well. So just a bit of housekeeping before I kick into the substance of the webinar. My name's Jen. I'm one of the here, and I just wanted to thank you for taking the time to attend our webinar. Part of our requirements for delivering these webinars is that we are required to record the number of participants that attend the webinar. So it'd be fantastic if people are attending could write in their first name and last name box. If there are more than 2 or 3 people listening on a computer, it would be great if each person could write their name as a participant as well, just for our own records and reporting on these webinars that we deliver. Just a bit of technical stuff. If you want to change the participant name, there's a button on the right of the row that says attendees in red. If you click on that menu button and then click on Edit My Info, you should be able to change your name. An issue with fitting all the names of the people that are attending in there, please just write the extra names in the chat and we're very happy to collate that information afterwards. If you're entering as a guest, please enter your name. At the end of the webinar, sorry, I'm just seeing a few questions come up on the chat. Hopefully there's no issues with the sound quality. I was just going to say actually also at the end of the webinar we will be asking people to fill in a survey if possible. It's just part of our reporting requirements just to say whether you found the webinar useful and informative. And if you do have any questions that sort of spring to mind when you're watching the webinar, definitely feel free to use the chat function at the end of the webinar to ask those questions. And I'm very happy to speak to anyone after the webinar as well. This is the first of a series of education law webinars that we will be delivering. So this is Module 1. It's a really nice general module which gives you a nice overview of some of the basic issues that you encounter in education law. And sort of each module as we move through the series will deal with specific, more targeted issues such as special education or search and seizure in schools. So hopefully this gives you a nice, easy introductory overview and then you can get a bit more detail later on in the other modules. So without further ado, I'd like to kick off. Hopefully everyone with entering their names as participants and there's no issues with that, and obviously use the chat box if you feel you need to, and I'll be happy to answer any questions at the end. The module, essentially, I'd like to talk first about the right to education and just generally why this right has been protected. Then I'd like to talk about some of the more generic issues that students encounter, from enrolment to fees to uniform infringements, and what happens with parents' rights interacting with school. So just to get started, what is the right to education? So the right to education is protected in a number of ways. First of all, New Zealand has domestic law, which is domestic legislation that the government has enacted. And in the particular legislation I'm thinking of in this case is the Education Line. In particular, Section 3. Section 3 is quite clear. It sets out that all New Zealand citizens between the ages of 5 and 19 are entitled to enrolment at a state-sponsored school and are able to receive free education. The key point of that is there shouldn't be any ability to bar a child from entry into education if they are a New Zealand citizen, and there are recent amendments to some of the immigration laws and policies which provide for instance, children that may not be illegally here via immigration status to enable them to attend education as well. So there's been some recent amendments to that, and obviously this is primarily because of a number of international conventions as well. And hi, I've seen a question from Monica. Yes, there will be a recording of this afterwards, and yes, you can request the PowerPoints of these slides as well afterwards if you are interested. But yeah, as I said, we can deal with that at the end of the webinar in terms of getting you guys to fill in a survey about how useful you found the information and whether you'd like a copy of the information as well. Yeah, so back to what we were talking about, which is the right to education. International law very early on set out that there was a right to education. So there's the International Covenant on Economic, Social and Cultural Rights. And it was one of the first very important international conventions that was set down by the UN. Really important because it sets out that all children have the right to education, and that governments have the obligation to ensure that all children are able to obtain at least primary level education, if not further, and vocational training in each of the countries that are signatories to that international convention. And then that's just continued to develop through a number of international conventions. So there's a number of policies, directives and international conventions which deal with the right to education on the UN website. Obviously I won't go into detail about all of them, but one of the most important ones I'd like to mention is the United Nations Convention on the Rights of the Child. This convention was very key, 1989, by the New Zealand government, and it sets out very clearly that young children have rights and dignity in themselves, have the right to self-determination and have the right to access an education. And it has to be an education to a standard which enables them to gain basic numeracy and literacy skills to function in society. What is great about the United Nations Convention on the Rights of the Child is that the government is required to report to the United Nations periodically about the progress they're making in respect of each of the rights that are provided for under the United Nations Convention on the Rights of the Child. I would say if you do have time, maybe to have a look at the report that's been published by Action for Children and Youth Aotearoa. They actually take a different slant on the government's report to the United Nations and highlight some of the issues where the right to education hasn't been as given as much effect to as it should be in New Zealand. And it's just an interesting read, particularly in respect of things like special education, or how they're dealing with particular ethnic groups that are facing more exclusion from education or otherwise. So yeah, just worth having a read of. But essentially what you need to know, and the take-home point from this slide that I'd say is that the right to education is protected by law. We can point to a specific section in New Zealand law, that's Section 3 of the Education Act 1989, and there's also a lot of international law that protects that right as well, which is part of the overall law of New Zealand. Why is that important? I guess because one, it's an enforceable right in theory because it's a right that's enshrined in domestic and international law. It's sort of been a bit harder to enforce that, as you'll find out in some of the later modules in terms of a specific right, particularly where there's a right to, for instance, special education. But just essentially so you know, if you ever get asked where does the right to attend school come from, Section 3 of the Education Act and probably the most important international convention, the United Nations Convention on the Rights of the Child. Enrolment. So this is one of the biggies that a lot of people that call up Youth Law's advice line face. So there's a particular enrolment scheme set out in the Education Act 1989, which relates to the right to education under Section 3 of the Education Act. What the Education Act provides for, in particular policies that inform the Education Act, is what's known as a zone system. So if a child is within the local zoned area of a school and they're a New Zealand citizen and they're between the ages of 5 and 19, they have an absolute right to enrol in that school. And what that means is a school can't refuse enrolment or say that they have to enrol at another school if they don't want to enrol that student. If they're in zone and they meet all the criteria, they are entitled to a right to education under Section 3 of the Education Act at that public school. It gets a little bit different when we're talking about things like private schools or other schools such as state integrated or charter schools, but essentially what you do, the take-home point I would say from that is that public schools don't have a choice in the students they enrol if a student is in zone, locally living, and within the ages and a New Zealand citizen. When a child is outside of zone, which quite often happens, we hear this a lot with schools such as Central Auckland schools like Auckland Grammar. There are school ballot systems for students that are out of zone, so they can apply via the ballot system to be accepted into that school, but there is no means by which they can guarantee or say that they have a right to attend at that school. So very often you do find that some of those schools where they have very high demand for enrolment may be asking parents for proof of their living status in the area, for example, electricity bills or otherwise. So if you're providing support for a young person in that situation, sometimes that documentation might be important. There is the provision within the Education Act to direct enrolment in a particular place sometimes. So under Section 11P of the Education Act, there is provision to direct or essentially force a school to accept enrolment of a student. This is only utilised in particular circumstances. Obviously, it's not going to be utilised just because a particular parent or student feels that they would rather attend a school in the next zone over. Usually, there needs to be quite compelling reasons or particular issues that mean that it would be better to have a direction to have that child attend at that school. The Ministry of Education does step in and help with directions. They have a power under the Education Act to direct enrolment of a student at a particular school, but what you probably need to know about this power if you're ever supporting a young person in that situation, it's used very sparingly by the Ministry of Education. They'll only use it very, very sparingly in quite special circumstances, and generally only where a student is under the age of 16. So you're probably aware that when children reach the age of 16, they can choose to leave school. Before then, they need to be enrolled in school, otherwise they will be considered truant. Once students are over the age of 16, it seems to be quite a lot more difficult to get Ministry of Education assistance to get a direction for a child to be enrolled at a school over the age of 16. But obviously, I would be saying if you're supporting a young person who's under the age of 16 and there are very compelling reasons for them to attend a different school and there's a good reason to seek a direction, it's worth sort of haranguing the Ministry or continuing to ask the Ministry to assist with that cause. Some of the cases that we might have dealt with in the past that are quite similar to this sort of would be where, for instance, the child was extremely badly bullied at a particular school because of special educational needs. It was very isolated from that entire school community in a direction at a school that was not in zone but actually had the ability to accommodate those special needs and enable the student to have a fresh start. In some cases, the Ministry was willing to step in and help with something like that. So just something to bear in mind if a young person potentially is still very interested in staying in education but is having real difficulty with the current schooling situation and the zone in which they are in. So, free education. What does free mean? Because I've talked a lot about Section 3 and the fact that Section 3 says that every child that's a New Zealand citizen is entitled to a free state-sponsored education as long as they're in zone and they're between the ages of 5 and 19. So you'll remember I mentioned briefly that a New Zealand citizen and a resident has the right to free enrolment in education at any in-zone, state school or partnership school. Important to bear in mind that different schools that aren't public, for instance, private and integrated schools are not necessarily free, so there may be school fees required to access the basic main curriculum. If you're attending a public school and you are entitled to free education because you're a citizen and you're within the ages, then you're entitled to access all the basic main components of the national curriculum. So that would be your basic maths, English, science, etc. And you should not be discriminated against in any way for seeking to participate in that curriculum. Charter schools are slightly different. You've probably heard quite a bit about them. There's been a lot of controversy in the news about them. Obviously, it's a very different model in terms of how they administer education, and they don't necessarily follow all the sort of curriculum guidelines that a public school follows, and you'd be aware that they don't have a board of trustees like schools usually do, and they don't necessarily hire teachers that have been through a particular training process. So essentially the take-home point from that is charter schools are still state-funded to provide alternative curriculums, so you would expect that the child that's attending that school still has the ability to access a basic mainstream curriculum, although it may be provided in an alternative format, but should be gaining the literacy and social life skills to prepare them for the future. Fees. So the whole thing about public schools and being state-sponsored is that there shouldn't be any fees to attend a state school. So you hear a lot about schools asking parents for their compulsory donation or their school fees for the year. So very often parents might be sent home an invoice with their child asking them to pay an annual levy, and it's sort of assumed quite often that this is required. It is quite common for schools to ask for donations to help with running costs. Part of the reason for this is partly because of the way schools are funded. So there is a bit of a bulk funding model, and they do sometimes seek these donations to add to the ability to enhance the curriculum or deliver other subjects or provide other resources. What is important to bear in mind is that they are still donations. So unless you're dealing with a private school or a school that can charge fees, there should not be a cost associated with a child accessing the basic mainstream curriculum, that is the usual maths, English, science, etc. Sort of different when we talk about things that are over and above the normal curriculum, which I'll get to in the next couple of slides. What we also hear a lot of is that schools are now even asking parents to buy uniforms or stationery from approved suppliers or particular branded uniform or stationery. There is nothing in the Education Act and there's nothing in the law which enables schools to demand that a particular type of stationery or a particular type of uniform be bought. The Education Act is broad in the sense that it allows schools to set rules for the good running of the school, and it allows them to ask students to wear uniforms for the purposes of maintaining a school identity and all the rest, but there's nothing in law that allows them to demand purchase from a particular supplier or a particular brand. So what we hear quite often is there's a lot of pressure on parents to buy the more expensive suggested brand or buy specifically from a uniform supplier that the school has a relationship with, even if it's vastly more expensive than another supplier who might be supplying something essentially the same. So I guess the take-home point from that is the school can't force you to shop at a particular place or buy a particular brand, although yes, there may be quite a bit of pressure to do so. So yes, as I said, students can't be treated differently because they don't buy from a particular supplier or buy a particular brand. So if a student is being treated differently, either because they're being excluded or disciplined because their uniform is in a particular brand or whatever, that could be actually almost discrimination under the Human Rights Act on the basis of family status, and also it could be an improper use of disciplinary provisions under the Education Act. One of our later modules in this series will actually talk in depth about the power of schools to discipline, so I won't go into it too much now, but essentially just to say that the school might be misusing those disciplinary provisions or actually discriminating against the student if a student is treated differently for not having a particular brand of uniform. So again, school donations are not compulsory. So if you're ever supporting a young person and they're being treated differently or being removed from mainstream class because they haven't paid their school donation, they have a right to attend education and have a right to that mainstream curricula. I just see questions come up on the screen. If there is an entitlement to free education until 19, that should cover the cost of tertiary education for under 20-year-olds for those who have finished at secondary schools. Not necessarily. So the definition notes that it's at state-sponsored public schools. Tertiary institutions aren't completely state-sponsored, so the Education Act definition wouldn't include, for instance, a university degree education, but it would cover your primary and secondary education, provided the student still wanted to stay at school up until that age. I hope that makes sense. So yes, back to school donations. What we have heard about, and I think quite recently in the newspaper, there's a story of a school that was excluding some students from their parents hadn't paid donations, and they were being excluded from mainstream English, Maths and Science. In our view, that something like that would be illegal, although the Education Act provides quite wide powers to schools to discipline and maintain the school. The right to education is quite clear, as I said, under Section 3 of the Education Act and under the international law that I talked about. If the child was being excluded from extracurricular activities, that would be different. So if it was like school sports after school or an extra over and above class that required extra resources or fees, that would be different. But if we're talking about mainstream basic numeracy, literacy and science skills, a student should never be excluded or treated differently if their parents have not paid a donation, if it's a public school and they're entitled to be there and they're in zone. Another thing that we keep hearing about quite often is that students are penalised if their parents don't buy them certain items, so things like laptops or iPads, which have now become quite commonplace in quite a few curriculums around the country. There's no requirement in the Education Act to say that you have to have a particular type of electronic device to participate in mainstream curriculum. The school is required to make sure that every student can access the curriculum even if they don't have an iPad. So otherwise, if they were to say that only students with an iPad can access this, it would essentially be discrimination against that student and treating them differently. And I hedge a bet to say it would probably be considered discrimination under the Human Rights Act, discriminating against that student on the basis of their family status. So what can the school charge for, really? And so that leaves you with knowing that if it's a mainstream subject and the student is entitled to attend, they shouldn't be charged, but at times schools can charge. So some of the things they can charge fees for include things such as take-home items, activities or events that enhance the curriculum. So this should be something that should be advised beforehand, so parents should be made aware of it, and they should be made aware that this is something over and above the normal curriculum. So one of the examples I've listed there is sports activities. Another one might be a special school camp for biology, or a sports trip out to another city to compete. The thing about these is it's a bit of a grey area. Although if you take a strict legal analysis, it is over and above the basic curricula. What is important about a lot of these activities is they actually give students opportunities to learn outside the classroom and enhance their learning. So in a way, it is part of the overall learning experience. It's just enhancing it. So it is really nice when a lot of schools, instead of discriminating against students or saying that only those that can afford can go on a biology trip, and when they do fundraising to try and allow all students in the class to go, because obviously that gives you a sense of everyone being included, and also everyone gets the equal opportunity to enhance their learning in their science subject, for instance. The best thing is, if there is any concerns or issues with this, the best thing to do is talk to the subject teacher or principal and see what can be done. Very often schools can be very accommodating as long as you have a very frank and open discussion with them. So if you are supporting a young person through something like that, it just is something to bear in mind. Obviously, it's better if the young person can participate as much as possible to enhance their learning. So as I said, I've sort of thrown in a little bit of law here. It's not something you need to essentially remember, but it is a bit of a grey area in the law when you're dealing with a child that's being denied access to things that are over and above basic curricula. So they do help them learn, but there's not a clear right to it. It does become an issue, we found, with some of our clients. For instance, some students have been refused the ability to buy a ball ticket or yearbook. So they may not have paid the donation, but they've had the money and they were ready to front up to buy a ball ticket or a yearbook, and they were told, no, you're not allowed that because you didn't pay a donation. I would say in that circumstance that's potentially unlawful, because there is no right of the school to demand the donation before the child is entitled to purchase something for which they have money to purchase. So it's a bit of a grey area, and it almost does border on punishing the student for sometimes something that's out of their control, for instance, whether or not their parent has decided to make a donation to the school. I would make the argument that although it's not part of the core mainstream curriculum, a lot of these activities do enhance the overall schooling experience for a young person, and it can be really important. It's a really important part of the socialisation process to attend the school ball. It's really nice to have a school yearbook to look back on, so it could constitute unlawful discrimination and breach of the Human Rights Act on the basis of the young person's family status. It's never been tested in court. There's never been any case law that's been taken, and there's very little commentary that's been published about it. Even the Human Rights Commission hasn't published any opinion on this, so this is just our sort of interpretation of how we think the law potentially might fall when you're looking at a grey area like this. But obviously, always best not to resort to quoting the law, but rather trying to work with the school and seeing if there's a compromise so that the student can participate as much as possible in education. So I just want to move on to talk a bit about parents' rights now. It's a bit of a hard area because obviously we find it's very hard because obviously our client is the young person, and you probably experience very similar issues at times where you're wanting to do something that is compliant with a young person's wishes or best interests, and parents also feel that they have rights and duties and obligations and a say in matters as well. So where do they stand in terms of their rights with the school, and how far do those rights extend? So under current sort of policy, legislative requirements, schools do record guardianship details. So default position is mum and dad, when child is born, are automatically deemed to be guardians. This is defined under the Care of Children Act, which sets out duties, powers, rights and responsibilities of guardians. Guardians essentially have a say over big decisions in a young person's life, so big medical decisions, big life decisions, and guardianship endures until the age of 18. What is important and is tempered against this is the right of a young person to self-determination. So you'll remember I talked about the United Nations Convention on the Rights of the Child, the International Convention, very important convention. It sets out that young people have a right to self-determination and autonomy as well. So I would say that when a young person has autonomy to make decisions, is cognizant of what they're doing, even though guardianship endures until the age of 18, probably at a much earlier age, the right to autonomy and self-determination exists under international law. Also, at age 16, children are able to leave home and leave school, and that is a decision that can be made by that 16-year-old, even if guardianship endures until the age of 18. So guardians, yes, as I said, are generally mum and dad, biological mum and dad. They can also be appointed by the court. So, for instance, say care has been taken over by grandma and grandma's been appointed a guardian, then grandma would have those same guardianship rights set out in the Care of Children Act 2004. What this means for schools, and I guess for anyone that's dealing or liaising between schools and families, is that parents and guardians have the right to be informed of major matters affecting the young person. The only time it really becomes a massive issue is when you've got fractured families. So if a family has, the couple is separated, there may be differing opinions on the child's ongoing education or accessing aspects of the curriculum. And usually the school, and it is quite good practice for the school to have a default contact parent and to make sure that they're aware of any differences between the parents as to how things are to be done with the child. Where it gets particularly difficult is if you're dealing with protection orders. So protection orders where a parent may have taken out a protection order against another parent. That would limit the ability of the parent to work together with the other parent in conjunction with the school. And another thing that stems from that is often children are automatically included in protection orders of a spouse. So if you've got, for instance, a mum with a protection order against dad, children will be automatically usually included in the protection order, which means that if dad comes down to the school and demands information and mum's the default contact, potentially dad, by making contact, coming down to the school, would be breaching the protection order to see the children. So there are a number of issues with that. So I guess it's always about treading carefully when you're dealing with situations like that, and very often the school will ask, you know, what are the custody orders in place, is there a default contact, and how often is custody shared, and just knowing, for instance, that those things are happening can sometimes help with some of those issues. For instance, if there's a transition between changing place of residence and custody midweek or otherwise. So what about parents' rights to enter school? So just wanted to talk about whether school is a public area or not. So I always think, you know, we can go out wherever. So we can go to the library or the courthouse, and it's a public place for us. We're allowed to enter it. We can go, and we all have a right to. But the distinction is that schools aren't actually considered public places like a library or a courthouse. So that's defined under the Summary Offences Act. And we've got to temper against that the fact that schools have got national administration guidelines that have been issued by the government to comply with. So they've got duties to provide a safe physical and emotional environment for students. What does that entail? That entails many things, from safe emotionally as well as physical safety and boundaries. A lot more information about that can be found on the Ministry of Education website if you do want to read a bit more about the National Administration Guidelines. I will talk a little bit more about them in some of the later modules, in particular when I talk about things like special education, but we'll get to that a bit later. But essentially for now, just to let you know that those are there. And the Ministry of Education also has issued an action guide and schools deal with health and safety on site. And a school won't be responsible for those that are on the school ground without the consent of the school board. So essentially, if a person is not allowed to be on school, that's going to be a trespass, and it's not going to be something that the board's responsible for. So, parents at school, parents or guardians. So again, you remember how I talked about the fact that, you know, not just parents, but people who've been appointed guardians have a right of entry to school. Under the law, under Section 319A of the Education Act. This is usually for things like pick up or drop off of a student. Important to note in there that step parents aren't included as parents under the Act, and they need to be court appointed as a guardian. So yeah, harking back to that old slide where I talked about the fact that guardians are appointed, so they don't have that right to have major say in those major decisions of a young person unless they've been appointed a guardian. Section 70 of the Education Act allows parents a right of entry to any licensed early childhood centres or licensed home-based education. So that deals with your early education places as well as, you know, your public schools. There are for instance, where I talked about earlier protection orders. There might be court orders or other orders, for instance, trespass or harassment orders issued by the court where a particular person has exhibited risky behaviour and they've been told to stay away from school. And, you know, further police action could follow from that if they do breach any of those orders, which I'll talk about in a bit more detail in a later slide. So what happens when there's bad behaviour? So I'm sure Oh, yes, so I've just had a question pop up on the screen. Can I clarify, does right of entry include parents going into class to observe a teacher and child? The long and short answer of it is it's a grey area. So it's pretty clear that the purpose of the legislation, so that earlier slide that I was showing you, that was sort of the interpretation of it, and the policy statement around it seems to indicate it's intended for pick up and drop off. Observing a child does not necessarily fall within it, and I think it would be a very wide interpretation of the rights under that section. But what I would say is if you take a broader look at some of the other rights that are available in terms of the right to participate in the child's education and have a say under government policy under the Education Act, there may be a good argument to interpret the right of a parent to be involved in their student's education to come in where reasonable, and I'd add in a sort of with where reasonable caveat to observe their child. We hear about this a lot with special education students, so very often parents do need to come in and observe or assist, and usually that's with the consent of the school. I think the only issue arises when there isn't consent of the school or there's any dispute between a school and a parent about this. What I would say is obviously first and best case scenario is to work with the school and cooperate and seek mediation or restorative practices to try and discuss any issues that arise, because there is no clear legal answer to it. I would be able to point to a few bits of policy and a few bits of international law. For instance, the earlier international convention that I mentioned, being the International Convention on Economic, Social and Cultural Rights, talks about the rights of parents to be involved in their child's education as well. But there's no specific section of our domestic law or a specific clause that I could point to which says there's exactly that right. So it's a bit of a grey and difficult answer, but essentially it's not clear. So just to get back to the bad behaviour issue, so sometimes, parents don't always behave well and things don't go well with the school. So when bad behaviour happens, there are a few things that can happen legally if a parent harasses or threatens anyone at the school or any staff members. They may make a complaint to the police. The police may investigate and take further action. That may just be a warning, or there may be further criminal charges that flow from it if it does escalate to the point where they feel there is a risk to safety. It is possible for a person that feels they've been the subject of harassment to apply to the District Court for a restraining order under the Harassment Act. I will go into that in a bit more detail in later slides. The school, as I said, is not a public place as you would consider a library or a courthouse, so they may actually issue a trespass notice. So you or I in our private homes have the right to issue a trespass notice to anyone that steps onto our front yard or our front doorstep that we don't want there. And very much the same principles apply with the school. The School Board of Trustees can issue a trespass notice to someone saying, get off the property and we don't want you to come back. So we've got a question here. How does this relate to parents harassing other parents? It's slightly different because you're dealing with two individuals which don't necessarily have any authority within the school. So it might be a little bit more complicated, say, if one of the parents is on the Board of Trustees and the other parent isn't. But if you're dealing with private harassment between parents, I'd probably go back to finding out what the custody arrangements are, if there's been any protection orders issued, and generally if there's been protection orders, the protection orders will set out that one parent can't harass the other parent, for instance, and then that would be a matter for enforcement through the courts for breach of those protection orders. Yep, parents from separate families. Okay, yeah. If you feel that, for instance, there's been parents of different students, I'm assuming you mean different students, who've behaved in a threatening manner towards another parent, very often the school may choose to take any of that action against only one of the parents or both of them. We have heard of that happening, and very often the school has tried restorative processes, so to try and get those two separate sets of parents together to talk out the issue. I mean, obviously, if it's escalating to the point where it's affecting the safety of students or other parents at the school, they may choose to do any of those things that I've listed in that slide there. So again, apply to the District Court for a restraining order. With the restraining order, it would probably be the parent that's being harassed applying against an individual restraining order against a parent who's harassing them. So it wouldn't be necessarily the school doing it, but the school may just support it. So if the court did agree that there was harassment and said, yes, we're issuing a restraining order, the school would probably have to support that and tell that parent to stay away because a restraining order had been issued. And as I was saying, a trespass notice, it is one of the easiest things a school can actually do because they just issue it. And as I'll talk about in a bit of detail in the later slides, once it's issued, if they breach it, then they can enforce it and seek police assistance as well. Under Section 139C of the Education Act, it is a criminal offence to assault, abuse or intimidate a staff member within the presence or hearing of any student of the school while on school premises or any place where students are assembled for school purposes. You can face criminal charges if you do behave badly and if it's an assault, abuse or it intimidates a staff member. And that will be a test which will depend on, obviously, the circumstances, and it's within the presence of a student. There is the potential for this to be reported to the police, for it to be investigated, and for criminal charges to be laid. So there is consequence for bad behaviour if it gets to the point where it is criminal seriousness. So a little bit more detail about trespass. You don't need to remember all of this because all this information will be available to you again in terms of specific sections, but it's just good to know that it is available. As I said, the school board is the occupier of the land and buildings under a lease from the government, so they have control over it. The school is not considered a public place, so any entry without consent will be a trespass. So if you're not consented to and you get onto the school grounds, the school can actually issue a trespass notice against you. Under Section 3 of the Trespass Act, what the person occupying the land can do first is make a request for you to leave. If you don't, then obviously there are further steps. So under Section 4, you can give a warning to stay off and tell them of the consequences, and also then issue a written notice of trespass. And there are sort of quite hefty penalties for some people if they do breach this. If a person willfully trespasses within 2 years after this warning, they can be fined up to $1,000 or face prison for up to 3 months. So obviously not very common for people to be sentenced to imprisonment, but it's still possible, presumably when it's in a very, very serious situation and it's been repeated or aggravated breach of that trespass. Restraining order. So you remember I talked a little bit about the fact that under the Harassment Act there is the ability to seek a restraining order as well. So under the Harassment Act, and this is something that can be applied for a local district court at the local civil counter of the district court, the court will grant a restraining order if a parent's behaviour causes distress or threatens to cause distress, if the behaviour would distress or threaten to cause distress to a reasonable person, the distress caused justifies making the order, and the order is necessary to prevent further harassment. Now, harassment is sort of defined quite specifically within the Act as well, and it's essentially there's got to be an element, a mental element aimed at targeting and harassing this person. Generally, if there is quite an established pattern or quite a bit of evidence, for instance, there is a chain of text messages or emails or plenty of witnesses to what's occurred, it wouldn't be that hard to build up enough of a case to show that this person had continued to harass another person. If the court decides and agrees with the fact that there is harassment and a restraining order is appropriate, they can grant an order and it will remain in place for up to 1 year. If a person breaches that restraining order and continues to contact that person or otherwise, they face criminal charges and imprisonment of up to 6 months and a fine of up to $5,000. So again, fairly serious consequences if they do persist and continue with their behaviour. I just wanted to talk a little bit briefly also about sports events and what happens with parents that behave badly at sports events, because it happens so often and we hear so much about it, about parents that are on the sidelines making very vocal their opinion about what should be happening. So parents do get angry and offensive at sports events. Common practice is for schools to send a warning letter. And importantly, there's also bylaws that exist for secondary schools and college sports, so they can refer to specific codes, policies and bylaws. And the good thing is also sporting associations also have their own code of conduct which set out standards for those involved in the sports as well. Under college sports bylaws, an authorised school representative has the power of abandonment in consultation with the referee if players, officials or spectators are at risk. The conduct of spectators who support a team must comply with acceptable standards of courtesy and conduct. Now, I think just taking an ordinary, reasonable interpretation of that, obviously, swearing at a coach or abusing them verbally or physically would not be appropriate. So if there are reports of a spectator engaged in physical or verbal attacks on any referee official, this can lead to disciplinary proceedings. Note that, importantly, misconduct within these college sports bylaws is actually defined to include a spectator entering a field of play uninvited by a match official, which happens very often. Sorry, just go back there. Yeah, it happens very often. So actually, it could be something that a person could find themselves on the receiving end of notice that they've breached one of those bylaws if they do that. So penalties for violations set out in the bylaws include things like public censure, denial of participation, suspension of anyone associated or connected with the team, removal of match points. I'm sorry, that seems to have covered that, but removal of match points from the person connected with the team and any other penalties that are deemed appropriate. Also, spectators can be banned from attending or being in the vicinity of matches for a period of time. Now that's quite powerful because it doesn't just stop their behaviour at the one game, but it can stop them attending a number of games into the future. As I said, working with the school is usually the best course of action. Often it is a matter of balancing competing interests for the school and thinking about all the students. Trying to maintain a relationship with the school is always better, and working together with parents and students is probably the most effective route rather than trying to argue or cite any sort of legal arguments. So that covers a lot of the kind of broad overview I really wanted to give you about the right to education and some of parents' rights and, common encounters that you'd have with issues entering schools such as uniform or fees. Here's my top take-home tips from the webinar, essentially. Hopefully it's a nice introductory one for you to just kind of get a feel for education law, and we can sort of give you a bit more detail with each of the modules that are to follow. So top take-home tips for today are, there's a right to education that is state-sponsored at public schools for all children between the ages of 5 and 19. Schools have no right to demand fees or donations from parents and students. And there's no way that students should be excluded from mainstream curricula if they can't pay those fees. Also, schools shouldn't be demanding that parents buy from certain suppliers and shouldn't be excluding students based on whether or not donations are being paid. If a child is in zone for their local school, they should not be refused enrolment, and you can ask the Ministry of Education to help you so they can use powers of direction, and indeed they should. They have an obligation to. If the child is not enrolled and they're under 16, the parent can be prosecuted for having their child being truant from school. So the Ministry of Education actually has a legal obligation to help you. So if you are assisting a young person, it's important to keep that in mind. There are certain laws that apply to parents, particularly if there are custody issues or bad behaviour. I've just seen a question pop up on the screen. Can a school send a pupil home if they arrive at school and are not in uniform for the day due to unforeseen circumstances? It's sort of a difficult question to answer because, yes, schools have the right to set school uniform rules, and uniform infringements can be a reason for discipline or removal of the child from school, but only if the school follows proper processes. So what I would say is they can't just, what they'd have to say is there is a legitimate reason for telling the student to go home, and we actually are invoking a proper authority to do so. So as you'll find out from one of our later modules, there are only very limited circumstances where the school can force a child out of school and they have to rely on the procedures and authority and meet certain tests set out under Section 14 of the Education Act in order to do so. It might be it's more appropriate for the school to issue or otherwise, but what I would say is if it's an unforeseen circumstance rather than any deliberate disobedience on the part of the child, a school would be very hard pressed to justify any disciplinary action or removal of the child from school if it was not the fault of the child, particularly as they're turning up and they're there to have an education for which is their right. So hopefully that gives you a bit of context. I think it will make a lot more sense if you do get the chance to tune into our Section 14 webinar. That will talk a lot about the rights of schools to remove students and how limited that power is and what sort of tests they need to meet before they can do that. Just looking at the next question that's popped up on the screen. Can I give a little information on right to education and how this applies to correspondence school and homeschooling? So you'll remember that I talked about the fact that public schools are there and they have to provide a basic mainstream curricula for free to all students that are eligible. So that's the New Zealand citizens between the ages of 5 and 19. Absolutely, that right to education still applies even if the student is attending correspondence school or homeschooling. So what that requires is, for instance, that a homeschooling curricula meet the basic requirements of the mainstream curricula, or correspondence school also has the components of a mainstream curricula, which would enable that young person to obtain and achieve an equal and comparable education to their peers, as is their right under Section 3 of the Education Act. So whether it's in a public mainstream school or whether it's through correspondence or homeschooling, that right to education still endures under domestic law, under Section 3 of the Education Act, and also under all those international conventions that I mentioned, including the United Nations Convention on the Rights of the Child. If you feel, I guess, if you're working with a young person or you find that there's a situation where they might not be receiving their right to education, it's perfectly legitimate to complain about that, even if it is correspondence school or homeschooling, because the same rights apply whether it's a public mainstream school or correspondence school. Are there any other questions from anyone? I'm just going to leave the chat box open another minute or so in case there are any questions. I'd like to thank you all again for attending the webinar. Just for those that missed it at the beginning, if there are any individual people that have logged in on one computer but they're not listed, if you could list your individual names as participants, because we just need to record how many people participate, and we'd be much obliged if you could please complete the SurveyMonkey link, which we've just put up in the chat box as well, just to let us know how you found the webinar, whether you found it useful and what you think could be added into it in the future. If you want some more information about us, there's a bit of information on the screen there. That's our 0800 number. As I said, we operate between the hours of 10 and 4, Monday to Friday, and we generally provide a free service as long as the client is eligible for anyone under 25 nationwide. A lot of the information that I talked about is also available on our website, and we update our Facebook page. We also have a smartphone app which young people or anyone in general can download, which talks about young people's legal rights. So yes, I don't think there are any other questions. If there are, a call or contact me via email. I'm very happy to talk to you. Thank you again for attending the webinar, and I really hope you can tune into our future webinars in the future. Look forward to a bit more in the future in terms of in-depth stuff. So some of the stuff that we're planning includes the right to discipline, special education, search and seizure, privacy in schools, and procedural rights and things like that.